Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Bring the jury.
Court with your internet besties.
Oh,
Sorry.
that's us. That's us. Hello, everybody. Welcome back. Happy Thursday afternoon. If you joined our Morning Laura Owen stream, then hello again. If you're just joining us for Care and Read, well, hello. What a day it is. It's such a busy day for me. Oh man, I have a meeting at 5.
I told you
8. I know.
that past
Nasty.
llama
She's the
was a
worst.
little.
When
You posted the schedule in the Discord, I was like, future llama's gonna be real mad at past llama for this.
Probably, but there's so much I want to talk about all the time. Like last night, I was taking the Hamvee Read Turtle Boy stuff and like breaking it down and matching it up with testimony. And I was just like, I can't wait till we get in and rewatch all of that stuff again. I'm so excited, but we gotta get going and finish covering this one because there's so many
I
of
know.
them.
I'm ready to get to the goodies.
Me too. Oh, girl, me too. Me too. Well, hello, Buffy. Thanks for joining us in the chat. Happy you're here.
I'm always here.
Hello, Dean. Hope you're doing well today. And Lady in Gray. Wink saying, let's go.
I know.
Absolutely. Hello, Mary. Lainey saying, oh shit, I was just replaying the low stream from earlier. Didn't see anything else on the deck for today here, but here you are. Yes. This was scheduled too. Maybe it just didn't pop up. I don't know. But yes, we are here to continue on the timeline for O'Keefe v. Reed, J.F. McCarthy's Waterfall Bar and Grill for the wrongful death lawsuit. So we are picking up where we left off. Remember, the last 2 days we've been covering them arguing about Colin Albert, whether he should be pulled from the army to do a deposition, what's going on. We didn't know. We didn't know what they were going to decide, except for the judge being like, how about you look into it more?
How about you go just knock on the door at the barracks and say, hey, we need to talk to him, because that's how it works. It's not how it works. Spoiler alert.
It is not how it works. And that was interesting to learn about what happens if you do get some sort of court legal thing and you are in basic training and then you have to take it up with the military's judge and legal people. What are they called? JAG, right?
Yes.
Is that the judicial system?
The Judge Advocate General.
Okay. Is that for all of the military or just certain like ones? Like, do they have
There's a JAG everywhere. It's JAG.
okay, so it's all one system though for the military. Yes. Okay. Interesting. See, we never get to learn about legal military stuff. Is this
Oh,
public?
I doubt it.
I doubt it too. I'd be interested though in
JAG
watching
is
some of that.
everything. I was Army, JAG was Army too. We have JAG everywhere.
Yeah, why are you yelling, Lainey? No, I'm just kidding.
Right? Stop yelling at me.
It was very interesting. So, but let's go ahead and get on into it because we are on a tight timeline because now we are in school mom mode, both of us. So let's get into it. Now our hours are probably going to be different here in the future.
These damn kids just keep getting away of our YouTube hobbies while the kids are at school.
Pesky kids with their times of getting out. At least ours get out around the same time.
True.
Even though we're an hour apart. So, all right. So we're picking up here on June 23rd of this year, where the only filing we have for that day is that Timothy M. Burke is now appearing for private counsel as Lieutenant Brian Tolley's attorney. There's been lots of talk about Tolley previously in this hearing, or I'm sorry, in this case, and he sucks. He sucks. And some of the things he had to say.
For you. That's what the S stands for in MSP.
Sucks. Maybe. That sounds about right. Hi, Kelly. Oh yeah, there was the show Jag from the aughts. I remember that show. I don't think I watched it, but I remember it. All right, so we have that happens. Then the next day is June 25th, and we got a status hearing. So we get to watch a quick 10-minute hearing, which is always fun. I don't remember what this one was supposed to be about, but it looks like we got Damon there for Reed at the top. We got Buck, who's there for the plaintiffs.
Buck.
Dealey, I don't remember. These two are with the bar. I can't remember who's with which one. I think Dealey is with Waterfall, and then Kristen is with CF McCarthy's. I think, but I don't remember.
I mean, are the bars actually even in this case? They're so like not. They're just like, we're here for the show. I'm here so I don't get fined, but also I brought popcorn.
Yeah, they're like, this is nobody's even because they're being charged with wrongful death for like over serving or accused. I'm sorry, not charged, but for like over serving and yada yada yada. Yeah, they file nothing in this case, next to nothing, except it'll be like, if Karen Reed wants a motion to quash something or change something or dismiss or reschedule, they'll file a yes, we agree, thank you. Her lawyers did all the arguing for us, and we just have a one-page like, yes, please. We would like to agree with her on that. And that is just about it I've seen from either of the bars. So I don't know if that's how it's supposed to go, but I think they're just like, maybe.
It's kind of like Big Brother. It's like, we're just let them fight it out. And
they're the floaters.
Yeah, they're the floaters in here in the house. They're just like, I'm just going to let Team Reed, Team O'Keefe, they'll just take each other out and we'll just go to the end.
Float to the end. Yeah, I think that's their strategy. It's a good one. Because as we've learned in the last couple days, there is a lot of hostility, it feels like, between the attorneys. Some emails we read that were spicy. And spoiler alert, it does not get better. It does not get better. They do not, have a kumbaya. They're not sending each other best friend bracelets at all. So I know. Why can't they just all get along? That's what Judge Gilday wants. I mean, come on. All right, so let's get into this hearing. Let me turn this closed caption on.
Remember, we can turn a 10-minute hearing into a half-hour conversation.
That's true. And we got about like an hour and a half to stream things today. So, all right, today's status conference is brought to you by one of my personal favorite channels, the Trial Channel. And if you haven't, go subscribe to them. Give them a notification bell. She does an amazing job of taking hearings and trials, getting rid of all the garbage of the silence of sidebars and lunch breaks. And so you just have all of the important conversations all in one. And it makes a 8-hour court day and brings it down to a couple hours. And I appreciate the hard work that goes into all of that. So let's go ahead.
You should get paid for that plug.
Anytime you need a commercial Trial Channel, I am here and happy to do it. As the lawyers apparently love to say all the time, I'm happy and willing to have that conversation. All right, let's see what they have to say today.
Please. Good morning, everyone. Today is Friday, June 20th.
There was a hearing today, too. Wonder how that went. I don't think it's out yet, the footage, but it'll be there for us to get to next week.
2026. This is the Civil D session at Plymouth Superior Court before the Honorable Justice Mark Gilday. Your Honor, the matter before the court is Civil Action 2483 CV 00692. Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CNF McCarthy's et al. Your Honor, for the plaintiffs, we have Attorney Daniel Buck present. For CNF McCarthy's, we have Attorney Kristen St. George. For Waterfall, we have Attorney John Dealey. And for Defendant Reed, we have Attorney Damon Seligson and Attorney Aaron Rosenberg, all present by Zoom, Your Honor.
Morning, counsel.
Morning, Your Honor.
Morning, Your Honor.
Enthusiasm.
Do you have Mr. McCabe's deposition later this morning?
No, Your Honor. This is Attorney Rosenberg for Ms. Reed. That's the subject of the pending motion to compel that's going to be filed imminently. Not the.
Oh, so there was supposed to be a deposition of Matthew McCabe, and There wasn't. Now we have to do a motion to compel. What are the odds? You don't say.
To the shock of no one.
Right? But there's no games being played here, guys. No games. Remember that.
The one you already have. We had, just to update you, the last 2 days, Ms. Reed sat for a full day of deposition noticed by the plaintiffs.
Oh,
Attorney
good.
Rosenberg, you're gonna have to get closer to your
Sorry about that.
mic.
I said,
Well, not that close. Let's not overdo it.
Let's make out.
how's this?
Rosenberg.
Go ahead.
So I was saying earlier this week, Ms. Reed sat for a full day of deposition noticed by the plaintiffs. Yesterday, we had the deposition of Michael Proctor, pursuant to your order on the motion for protective order.
Ooh.
Mr. Proctor appeared. The deposition began about 2.5 hours late at his request. But we did begin at roughly 12:30 and ended at 5 o'clock again at his request. But we were able to get started. That's from my end, the most recent update.
2.5 hours they had to wait.
What
for
other
that?
depositions have taken place?
Your Honor, Attorney Buck, on behalf of the plaintiffs also took testimony of Caitlin Boudreau, Miss Reed's sister-in-law, on the 17th of June. That went forward as scheduled. I departed the deposition early to appear in front of Your Honor, but I believe it concluded.
It's like kind of weird that, both Karen and her family are like showing up for their depositions and whatnot, but everyone else seems to be like, I don't want to. No, thank you. So interesting. And yet they wonder why the internet talks so much shit about them. Okay.
Firm Attorney Rosenberg accurately stated that we took testimony from Miss Reed on Wednesday of this week. We adjourned by agreement at the end of the deposition, and will work on securing a second date to continue that testimony in the near future.
Any other depositions?
No, Your Honor, I think the other ones that you were aware of from our end are all subject to motions to compel, including the Colin Albert and Brian Tully, which is the motion I had flagged for Your Honor at our last appearance in person, which is now filed and docketed.
Since our last status, Miss Reed's counsel did take testimony from Allie McCabe.
Correct. Thank you, Mr. Burke.
Okay. So, Attorney Daly, what depositions do you have on the list here?
Your Honor, we have Michael Camerano and Caitlin Albert, who are patrons of the bar. We also have a forensic scientist from the state police, Nicholas Roberts, on our list.
That's on July 10th?
Yes, Your Honor. Although that may get moved, Your Honor, but yes, it's on July 10th presently.
Okay.
Okay. And on behalf of your client, Attorney St. George?
Good morning, Your Honor. I understand that representatives from my clients are going forward later this month. And I do not know what other depositions are going forward later. That's the only ones I'm aware of at the moment.
Your Honor, if I could step in here, we've been kind of coordinating depositions with CF McCarthy's. There are two additional patrons who are at the waterfall, Karina and Nicholas Kolakithis. Those are presently scheduled for.
I think it's interesting that the two bars are working together on things, because you think one would want to blame the other one more. That CF McCarthy's overserved
Right.
her, or vice versa. So that's interesting that they're working together when everybody else can't seem to work together, email one another, talk to one another, do nothing together. But the bars are like, no, we're good. We're working together. Just don't mind us, Your Honor. Forget that we're here. We're fine.
For July 29th. They had to get moved from the 15th at the request of the Kolakithises. They could not make it on July 15th, but we're expecting it to go forward on July 29th.
Okay, sounds like we're trying, but we're not getting very far. So I guess a lot's gonna be determined through the motions to compel. And there was one filed yesterday, and when are the other ones gonna be filed, Attorney Rosenberg?
By Monday at the latest. We now have the opposition. If we can get them in today, we will, but I'm not sure because we've had 2 depositions all day the last couple of days, but we will get them to you by Monday at the latest. And that's only one remaining. It just relates to a number of departments.
If people want to cooperate. Which
Okay, I guess I'll get them when I get them.
The plaintiff's motions will be circulated and filed early next week as well, Your Honor.
And what are those motions?
That would be the motion to compel Aidan Kearney and the plaintiff's motion to compel further answers of interrogatories from Ms. Reed.
Didn't you already
Okay, and has the motion relative to Mr. Kearney been sent out?
Correct. We have good service on a subpoena. The motion has gone out. We have not received a response to the subpoena nor the motion to date.
And when's the 9/8 deadline over?
I believe it just passed.
Okay, so you'll have that filed next week?
Correct.
All right. So we already have a couple dates scheduled, I know, in this case and in the Barnstable case. But let's pick another status date a few weeks out. How about, there's no depositions on the 13th, are there?
Your Honor, this is Damon Seligson, defendant
Hello,
Reed.
Damon.
There was a 30B6 deposition of the town of Canton, originally noticed for the 2nd of July, that is going to be moved to the 13th at the request of the town. So that date, we will have a deposition.
Your Honor, can I suggest some dates later in July?
Go right ahead.
Attorney Seligson and I had discussed needing to reschedule a deposition that had been noticed for the 27th. So I believe that's open right now. And I don't see anything on the 31st. I believe those are 2 options, but I'll defer to counsel.
Yeah, truthfully, I'd rather have it sooner because we're getting close to the end at the end of July. So how about the week of the 13th? Is there any time to have another status so you can keep me updated as to the progress of discovery?
I believe there are depositions every day that week.
Okay, but we could do it 9:45 like we're doing now, right? So someone pick a proposed date that week. How about the 16th?
I was going to suggest the 16th, Your Honor.
I was just going to do that.
Think alike, Attorney Daly. That's good. So, anyone else want to offer anything else?
Your Honor, this is Attorney Rosenberg again. Just briefly, I want to make clear that the Brian Tully motion to quash relates to a deposition that's fully noticed and subpoenaed as of now on July 8th. So I just want to give you those specific dates because that'll be before our next status.
Okay.
Thank you.
All right. Thank you, everyone.
Thank you. Have a nice day.
Great, thanks.
Thank you, Your Honor.
It's riveting. Thanks.
Thank you all. So the matter continues to July 16, 2026 at 9:45 a.m. for status and July 10th at 2 p.m. for the motion to compel. Thank you.
Cool. Thanks for that. All right, now back to our thing. So there was a whole lot of nothing. Apparently they've been doing some depositions, which is great. There's also been a lot of depositions that they're not doing because some people, they can't be bothered. There's too much. All right, so on the same day, where's my little remote that I need to control my slideshow here? Here it is. You little remote, you're coming over here with me. It's your time to shine. Okay, and you can go up over here. There we go. All right, so All right. The next filing that was filed that same day is a non-party case per participant, Lieutenant Brian Tolley's motion to quash the subpoena and or for a protective order because, well, we know why he doesn't want to do his deposition. It's because there's a lot of not great conversations, a lot of bad things going on with the investigators. All right. So why does he not want to do the subpoena or wants a protective order? I bet I know. So here's what the document is basically about because we're not going to read them all. It's a 43-page document. It's really not necessary. We only are reading the ones that are, pretty good or give a whole lot of background. But we've already talked about him in the fall of 2025, I believe. All right. So we know that separately, Karen Reed has sued the police officers involved in the investigation, including retired MSP Lieutenant Brian Tolley, claiming they violated her civil rights, by trying to frame her. Her team had sent a subpoena to Lieutenant Tolley, ordered him to sit for a deposition, and to hand over a massive list of personal and professional documents spanning over 5 years. Because when you see the way that the police like to communicate with each other, it certainly is questionable of whether or not they had bias when investigating. Yes, the answer is yes. They said very horrible things. So Lieutenant Tolley is asking the judge to completely cancel this request, or at the very least, put it on hold and limit what he has to provide. Tolley argues that Reed is using this lawsuit to force him to hand over information for her other lawsuit before the rules allow it, because she is suing. I know he would be in her versus Massachusetts State Police and Canton Police Department. I want to say he's one of the defendants in her versus everybody federal case, but I don't know that for sure, but I'm probably. Remember, there's 4 of these. So the judge in the other lawsuit has scheduled a hearing on July 14th to decide whether Reed's case against Tolley should be dismissed entirely. I think that's the federal one. Tolley argues it is unfair. It's unfair, guys, to force him to do a deposition on July 8th, just 6 days before a judge might throw his case out of court. Do we think his case is being thrown out of court? I don't think so. He points out that another officer in the other lawsuit asked the court for permission to gather documents early, and Reed's team successfully blocked it. Tolley argues Reed cannot block discovery in one court while using this court to do an end run around the rules. This is a problem that I feel like, I was one ahead. That this is why you don't sue all the people all at the same time. Not just Karen, but like the O'Keefe suing her, and then him suing her, and then her suing all these people, because then it's like, well, yeah, but I have a different deadline over here. And this is why this is a clusterfuck. Now, the very first hearing that we got to watch in the O'Keefe one, her team had asked to consolidate these lawsuits into one big lawsuit because of this. And the judge was like, no, we're not going to do that, actually. We're not going to do that at all. That's too complicated. And here we are now. So that's great. Let's see. So Tolley then emphasizes that he was a high-level supervisor, not the primary field detective who handled the actual interviews, warrants, or arrests in the O'Keefe investigation. Reed is demanding 15 categories of documents, which include every text, email, and recording Tolley has regarding the investigation, various police departments, the O'Keefe family, and even records about his own employment history. Tolley argues that forcing a retired officer to sort through 5 years of texts and emails is an unreasonable burden, because it always is, especially since many of the items, like his personal employment disciplinary records, are legally protected and have nothing to do with O'Keefe's wrongful death.
Okay.
Right.
I feel like an entire lawsuit is an unreasonable part.
Right. Oh, I didn't see this coming. Yes, yes, you did. Stop. Stop the game. She warned y'all she was going to be suing you guys. So it's an undue burden. He's retired. What else does he have to do with his time?
It's interfering with his golf.
Yeah.
He was at home watching Cops.
Now, if the judge refuses to completely cancel the subpoena, Tully asked for a compromise that would postpone his interview until after the federal court decides whether to dismiss his case on July 14th. So it is the federal that they're talking about. That maybe heavily limit the documents he has to look for, narrowing them down strictly to communications he personally made as a supervisor regarding the O'Keefe case during the year 2022, and or completely block Reed from getting his private employee personnel files and records from unrelated lawsuits. They really don't want the public to see what the cops have
What's
been
in your records? What's in your records? What did you do? What did you do?
What did you do? Right?
I'm just
All right.
asking questions. I'm not making accusations.
No, no. So then Karen's team files their opposition to Tully's motion to quash. So Karen's team states that Tully is the latest in a line of witnesses who are trying to avoid handing over documents or answering questions by filing late, invalid objections, which are not wrong. We've read how many. Nobody wants to cooperate with Reed at all about anything, no matter what, even if they end up being plaintiffs in other lawsuits. They're like, no, no, thank you. Now, on May 19th, Karen's team sent a subpoena to Tully's lawyer. His lawyer accepted it and agreed to reschedule his deposition. Uh-oh. Reschedule or cancel? Apparently, there's some confusion between those.
Apparently, they mean the same thing.
Yeah, right.
The way
Now,
these lawyers argue, they do the same thing.
So pedantic. According to court rules, if Tully had an objection to the request, he was required to submit it in writing within 10 days by May 29th. Is that a safe harbor? I feel like it. Now, Tully did. No flashbacks.
It's a
I can't
rule
do it.
11 in civil court. It's rule 26 in family court.
Oh my God. Ugh. Still trying to shake off this morning. My goodness. Where were we? So Tully did not submit any objections by the deadline. Instead, he waited until June 18th to suddenly send an email objecting to the request and asking the court to cancel it. What are the odds? Tully's lawyers never reached out to Reed's team to talk through their concerns or try to compromise before running to the court, which violates standard legal procedure rules. And we all know that's a big deal. Safe harbor. Her next points are that Tully argued that this court should wait for the other lawsuit to move forward first. And Reed's team points out there is no rule allowing a witness who isn't even a main party in the lawsuit to pause a court schedule. And the excuse isn't important enough to halt the case. Because in this one, he's considered an other witness, third-party witness or something like that. Tully argued that the request of documents are too broad and unfair. Always
And
unfair.
unduly burdensome.
Yes. Reed's team responds that because he missed the 10-day deadline to object, he completely gave up his right to make that argument. Now, ultimately, Reed's team argues that Tully simply watched other witnesses push back and made a calculated choice to break his agreement and ignore court rules. And they are asking the court to show the legal rules have real consequences, which the judge said yesterday in a hearing we watched that subpoenas should mean something and rules should mean something. I'm sure he's going to take this well. Now, we got some emails to read that were addressed in this one. I'm not going to show them because I didn't redact shit. 14. I think
I
cursed.
need to read along with the emails.
You know where to find them? 20th, 129. Okay, so they are back to front. Okay. So on May 5th, Charles Waters, who's one of Karen's lawyers, sends an email to, I guess, these people, Tully's lawyers, right? Good afternoon. I understand that you represent Brian Tully. I have attached a subpoena for Mr. Tully in the above referenced matter. Would you agree to accept service on his behalf? Best, Chaz.
Chaz.
Well, he sent that on May 5th. May 19th, they send him an email back. Good afternoon. We are in receipt of your deposition subpoena from Brian Tully with regard to the above referenced matter. Attorney Burke will accept service on his behalf, but we are unavailable on June 1st. Attorney Burke would be on trial May 26th through June 5th. I will reach out to our client and get back with you with our availability. Best. Then Wednesday, May 20th, a few days later, Karen's attorney messages them, okay, let's schedule it for July 8th. Please confirm. Then just a short while after that one, like 7 minutes, they respond back, confirmed. Best. So they worked it out. That's when it was going to be. And then all of a sudden, Tully was like, I'm not going to do that. No, I don't want to do that at all. Everybody else is saying they can't. I want to say that too. So Tully replies back to Karen's reply about all of this nonsense. And many of the arguments are still the same. So we're as his initial one. So we're not going to go over those. But Tully's lawyers state they are open to meeting with Reed's legal team to try and talk through the issues, narrow down what documents she actually needs, and find a compromise on the timing. However, if they cannot agree, which they probably won't, because nobody's agreeing to do shit, they want the court to step in and pause the deposition or heavily limit the documents he has to provide. And then also on the 23rd, Kristen St. George appears as private counsel for C.F. McCarthy's. She is who we saw in that hearing just now that we watched. So then the next day, June 26th, there's a conference to review status, but I couldn't find it anywhere. So I just don't know if it wasn't allowed out or what, but I didn't find it. So it's fine. But Judge Gilday has some orders from that. So he ordered that Karen Reed is to provide the factual basis for the following statements in her opposition regarding Tully. And she says two things. Oh, wait. I forgot I put these on the same things. The first one is buoyed by the treatment that other subpoenaed witnesses are getting by resisting their deposition, and that the manner in which our other subpoenaed parties have been handled in this case. The judge is not happy about that because they're basically being like, they've been allowed to not do anything and it's all your fault. And the judge is like, excuse me, do you want to clarify that for me? Probably, Mr. Rosenberg.
You want to
What
say
do you
that to my
mean?
face?
Basically, yes. Because he ordered them to provide the factual basis for that. Like, oh, but at the same time, it's like, bro, literally everybody is doing this. Like, let's not put our head in the sand. We've been following this case with you, sir. Okay, that's exactly what they're doing. It is plain as day.
This has
But
been the complaint since it started, though. He always sits there and says, "Oh, this needs to happen. They got to make subpoenas mean something." Okay, well, you have you're wearing the black robe.
exactly. And I feel like he's not being hard enough on the people that he needs to be hard enough on. Instead, he's always hard on Rosenberg, which is quite frankly doesn't make a lot of sense. And that's not just me being biased there, but like we've watched it happen. The plaintiffs can go and do whatever the fuck they want and not, deposition anybody. All the third party witnesses are allowed to be like, no, I don't want to turn over documents. I don't want to do a subpoena. Whine. It's like, well, you've kind of
You keep letting it happen. Yeah.
So, yeah, why wouldn't they come to this conclusion? Well, everybody else got to postpone it for a couple months. Why not me? So sorry, but I do kind of blame you for that, sir. And then his order, in the motion to compel Colin Albert to attend his deposition was denied without prejudice. So for now, the judge is saying, listen, we're not going to pull him out of basic training, but later you can file this again when he's done, basically. That's what without prejudice means. The motion to compel Colin Albert to produce documents from January 28, 2022 through June 18th, 2025 is granted, though. So he has to turn over all of his shit for like 3 years, 2.5, 3 years. So it's a reasonable order, I feel, right? Because based on what we learned about basic training and things like that in the military, like that really does kind of affect to pull him out and make him, come to do that is problematic. That's
Oh,
apparently
it
not how
is.
it works.
In my
So,
experience, you miss a couple of days and that's
yeah.
with getting hurt. That's everything. Like, because you do get hurt. I know. And
Yeah.
you get sick
So,
and shit happens sometimes.
so I do feel like it was a reasonable order on his part. See, we can agree and disagree together, Judge Gilday. Then he has another order regarding MSP turning over documents. The judge denied Karen's claims about deadlines and that they are no longer privileged because the criminal prosecution is over. So he's like, nope, that's not the case. He did then order MSP to produce a privilege log like they should have a long time ago, and it needs to be in by July 3rd. See, this is what we're talking about, sir. She's been fighting this MSP turning shit over since last fall. And you're just now being like, okay, but where's this privilege log I told you guys about? My order should mean something, right, sir, Mr. Judge, Your Honor? So the next day, June 29th, a few days later, 3 days later, the judge makes some more orders. Okay, this is an order relative to the order of impoundment. So the judge, this is the spicy part, Buffy. This is the spicy time. The judge was informed that someone may have shared information that was supposed to be kept private under a previous court order. The order of
Yes.
impoundment issued on June 8th. This is regarding Michael Proctor, by the way. Now,
Yes.
every plaintiff, defendant, and lawyer involved in the case as of June 8th, 2026, must submit a signed, sworn statement to the court clerk by June 30th. They must detail everything they know about how the protected information was shared with anyone outside of the official parties and lawyers. I got goosebumps because this is not good. It's not good at all that he's making everybody sign things under oath that it wasn't them
Did
that leaked something.
you get to see the Twitter posts that brought this? Okay.
It'll be coming up. Yes. Yes, it will. So let's see. And then he also ordered that all lawyers must attend an in-person court hearing on July 1st.
Oh, yes.
That's the one. That's the one you've been waiting for, everybody. He's going to lose his shit, according to Buffy. So,
Well,
it's spicy-ish. So it's not great. This is not great. Until the court decides otherwise, no one is allowed to try to get any more information or discovery from the person whose information was supposed to be kept private. That's Michael Proctor, by the way, which I don't know why they didn't name him, but whatever. Maybe they didn't. I didn't think about it. Anyway, so that is on the 29th. So then Karen's team does a response to the court regarding the opposition to motion to quash filed by non-party Brian Tolley. So we're going back to this real quick. Oh wait, that's not, I'm reading this one. So just ignore that slide. We'll get back. Excuse me. We'll get back to that one. So I got 2 pages just to read here. There we go. All of the tabs all over the place. More reading. All right, so this is her motion to her opposition to the motion to quash. So, in response to the court's request, defendant Karen Reed provides clarification as to 2 statements contained in her argument against Brian Tolley's motion to quash. Remember, the judge was like, I want you to tell me what you think these things mean, which are presented below, along with additional portions of each that clarify Reed's meanings and were not included in the request. So, 1, apparently, this is the quote, apparently buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, subpoenaed witness Brian Tolley now seeks to stand in the same line by filing a motion seeking to quash his deposition. Hold on, I gotta plug my headphones in. 'Cause apparently they are going to die. Great. In fairness, I haven't charged them for like 2 days. So, rather, and the second one, the other quote from it, rather, it appears that Tolley simply watched the manner in which other subpoenaed parties have been handled in this case. The judge did not like those comments. Now, these 2 arguments refer to the fact that multiple third parties Reed had subpoenaed have either ignored such subpoenas and therefore the court's commands, or sought to evade them, which will likely leave her forced to conduct a dozen or more depositions during the final month of discovery in this case. And they got a list of all the fuckery. So, 1, on May 20th, Colin Albert informed Reed that he would be indefinitely available for a deposition after June 2nd and continued to refuse to produce nearly all documents Reed sought. On May 20th, Tolley, through his counsel, agreed to the July 8th for Tolley's deposition, which was moved at his counsel's request. 3, on June 1st, Brian Albert served objections to producing documents well after the deadline to object had passed, and the next day claimed to be unavailable for multiple weeks that followed his subpoena date. What are the odds? On June 1st, Nicole Albert did the same thing. Jennifer McCabe did the same thing. Matthew McCabe did the same thing. And Allie McCabe did the same thing, all on the same dates. Because remember, they are Ham v. Reed Turtle Boy.
And they all have the same attorney, which why would you do that?
That does not sound smart to me, but right. Let's see. Except there's a difference with Allie. She later agreed to appear on such date with only 2 days' notice and then testified that, in fact, she never had concrete plans, like reservations, traveling companions, requiring her to be away on the date of her deposition. Oh, was she not going with everybody else to wherever they were going? Because that's what it sounds like to me. It sounds to me like they were all thinking about having plans, and Allie just decided, no, never mind. We probably didn't. Now, on June 5th, third-party witness Michael Proctor filed his emergency motion for a protective order. June 16th, Julie Albert failed to appear for her properly subpoenaed and noticed deposition. June 18th, third-party witness Tolley suddenly served his motion to quash after his counsel had previously accepted service of the subpoena on his behalf and requested that Reed reschedule it, which she did. And 11, at no point before June 18th did Tolley object to the subpoena's request for responsive documents. These events form the factual basis for the arguments referenced above. So,
wow.
I think the judge wanted to be like, why do you blame me for this? Now, granted, they have not filed these motions to compel here. So I don't think he's going to like Rosenberg's response, his arguments here, like at all. That's just my opinion. All right. So now back to the slideshow here. There we go. So then the same day, Karen Reed files the motion to compel Nicole, Brian, Jennifer, Matthew, Allie McCabe, Brian Higgins to attend depositions and produce documents pursuant to the non-party subpoenas, right? So Karen is asking the judge to step in and force Nicole and Brian Albert, Matthew and Jennifer McCabe, Allie McCabe, and Brian Higgins to hand over requested documents and show up to their deposition. Right? The judge isn't letting people skirt by, right, Your Honor? Do you like all their pictures I used for them? Because
I
I picked
do.
all the
That's what
worst
I was
ones.
looking at.
I picked all. I love the Me? Or Nicole Albert, I mean.
That's my favorite one. That's why I was like, I love the one you picked for her. She's like,
Me? Pardon me. What? It's just a house. Now, her team sent out subpoenas in May, and instead of answering or objecting within the standard 10-day legal window, their lawyers waited nearly a month to respond. When they finally did respond, they objected to all the document requests, refused to provide any records, and claimed they were unable for the requested questioning dates in June. What are the odds? Guess what? They're going to be unavailable in June, July, August, all of them, because they're so busy. By pushing their availability out to late July and August, these individuals are delaying the legal process. Reed's lawyers argue that this delay puts the court's strict pre-scheduled timeline for gathering evidence in serious jeopardy. Reed's team points out that under court rules, people who receive these orders do not get to dictate the timeline or unilaterally change dates. Furthermore, because they missed the 10-day deadline to officially object to the document request, the law considers their right to object to have been completely waived. Reed is asking the court to order these 6 individuals to immediately provide 3 separate dates they are available to be deposed before July 17th. She also wants the judge to order them to hand over all requested documents within 10 days. I just don't understand. They didn't do nothing wrong. Remember that. They are suing her and Turtle Boy for defamation because they didn't do nothing wrong. And yet, we don't want to turn over anything. We don't want to talk to you. We don't do anything. We're just normal people living our lives. And let's see, there are some emails. Of course there is.
emails.
Page 8. There is an email from Kieran Murphy to Waters. Now, Murphy and Jim, all of them, they're the lawyers for the House defendants, we'll call them, which just says, per your, I'm sorry, no, my apologies. It starts off with Waters to these people's attorney. Per your agreement to accept service on behalf of the above referenced individuals, kindly see attached subpoenas, to which then Murphy responds back, thanks, Ches, received. All right, not that illuminating. They're not all going to be bitchy, but they might be later. You just never know. But again, confirming that, hey, we received them. We know them. I'm sure the judge is going to love that. June 9th, 9/20. Let's see what the next one is. June. Okay, so we're backwards again. So then there is a message. Oh, wait, that includes per your agreement on May 5th to accept service on behalf of these individuals, kindly see attached subpoenas. Right. Okay. So then Kieran messages him back on June 1st. He emails him and says, attach, please find responses and objections to the May 5th subpoenas that were served on non-parties, Brian, Nicole, Jennifer, Matt, Allie, and Brian Higgins in the above reference matter, copying in all counsel of record for transparency a month afterwards. Also, please note, Allie McCabe is not short for Allison. Regards, Kieran. Like, who's supposed to fucking know that? Everybody knows.
Just Allie.
It's just Allie. Did you know that? Would anybody
No.
just assume that? No. A reasonable person would assume her name is Allison. And Allie for short, because that's normally what happens. But sure. Kieran has some sass too.
Well, fucking ask for her damn birth certificate so you can get the name right, so we can get this shitty attitude.
Right. So then June 2nd, is that the same day or when? Oh, it's the day after. Waters emails him back. Massachusetts Civil Code 45 requires objections to subpoenas within 10 days after service. Here, that deadline passed on May 15th without objection. Therefore, the attachments to your email below are not effective objections. Please produce all responsive documents immediately pursuant to the properly issued and served subpoenas that require production of responsive documents by June 1st so that I may have them in time for the depositions. And Murphy emails him back that night at 9:20 p.m. Chaz.
Oh my goodness.
These subpoenas
Chaz.
were mirror images of the one Ms. Reed previously served on Colin Albert, about which we've already had a meet and confer. So you've had our position on their vagueness and overbreadth for quite some time. Well, then why didn't you respond sooner if it's all the same? What kind of argument is that? Okay. We've relayed on multiple occasions that we are unwilling to produce over 4 years of communications among family members and others in response to non-party subpoenas that do not make any good faith effort to tailor the request by topic or scope. The outcome of your pending motion to compel compliance with Colin Albert's subpoena will undoubtedly influence these identical subpoenas, and we will modify our responses and objections accordingly, and to the extent necessary, follow the court's ruling on that motion. With respect to the depositions, our clients are not available on the dates proposed in the subpoenas. Their availability to sit for depositions in the wrongful death action is as follows. Brian Albert, July 20th to 31st. Nicole Albert, July 20th, 31st. Jennifer McCabe, July 23rd to 24th, or the 27th, 30th, August 4th to 7th, or August 10th to 14th, because she's just a busy soccer mom, guys. She's just a busy mom, and it's summer school time. She's only available a few days.
Well, that's why she keeps the peanut butter and jelly in the car. She's too busy.
Matthew McCabe, July 27th to the 29th, August 4th to 6th. He's not as available. Allie McCabe, June 22nd or July 20th. And Brian Higgins, July 29th to the 30th. That's it. That's the only times you're available up through August 17th. Okay. Please let us know which of these dates also work for the parties in the wrongful death action, and we will confirm the depositions with each of our clients promptly. Right. I don't think you will, though. I don't think you will. I think what you did is give a few dates for each of your clients, and then you're going to schedule them and be like, whoa, something came up. I don't know. That's what fucking Jen will probably say. All right. So back to the 29th. So then we're going to call them house defendants because that's what they're going to be called in numerous cases. So it's fine. They reply. And the outsiders, that's what the lawyers call them, the outsiders, argues that just because they were a little late sending in their written objections, 17 days late. Hold on, there we go. 17 days. That's just a little minor tardiness. It doesn't mean they automatically lose their right to object. They state the law generally reserves that harsh punishment for people who are deliberately stalling, whereas they are acting in good faith and keeping in touch with Reed's team. Right. Okay. We have very different definitions of keeping in contact, but okay. Now, their lawyer claims the request for documents are completely unreasonable and way too broad. Karen Reed is asking for 4 years' worth of all personal messages, documents concerning various individuals. The lawyer points out that the court already looked at an identical request sent to another person, Colin Albert, and agreed it was way too broad, even though we just read his ruling that not so much. Too broad. Okay. The lawyer explains that the outsiders have never refused to be deposed. However, Karen's team picked interview dates without checking if anyone was free. Right. You had like a whole month, but okay. The outsiders offered several alternative dates during the court's allowed timeline, but Reed's team rejected them simply because they preferred earlier dates. They did not give that many dates, in my opinion. Their attorney met with Karen's legal team to discuss the depositions, and her team did not say they were busy on the alternative dates. They just stated the alternative dates were too far off from what they preferred. He explained to Karen's team that the dates Reed picked conflicted with the pre-planned summer vacation schedules of the witnesses and their lawyers, because that's important. Vacations are important. He also notes that one witness, Allie McCabe, was already deposed on June 18th, and another, Brian Higgins, was scheduled for July 9th. The remaining witnesses offered specific availability windows spanning late July and August, but Reed's team refused to accept them. And we got some more emails. Though, whenever the opposition side puts these emails for us to read, they usually don't do them any favors. Like, why would you put that in there? You do not understand what cooperation is.
Doesn't that always seem to be the case when people try to include like text message? I mean, it literally happens everywhere. It's like, look at the text. This will prove it. And I'm like, yeah, but your side sounds bad too. Like, this is not
Right.
helping you.
It's not great. Not great. All right. So what do we got here? We got Monday, April 27th at 11:24 a.m. Murphy sends an email to Reed's team. Attached, please find non-party Colin Albert's responses and objections to the subpoena that was served to him on April 21st. What does Colin matter? Okay. We already read these. These are about Colin. All right, hold on. I'm trying to find one that's interesting, but they're all.
But didn't the judge already rule on Colin? Like,
Yes.
why are we still hashing out Colin?
Yeah, these we already actually read these. Yeah, we already read those. So never mind. That's not important. It's about something that's not relevant to the clients you're specifically talking about. But okay.
Yeah, this has been, my gosh.
They're ridiculous.
Sometimes I feel like the attorneys are so incompetent. I mean, not that I'm an attorney, but like also stop.
Yeah.
Some
All
of
right,
it
well,
just
then
seems like common sense.
Right. All right. So Karen's reply to their BS. All right. So Karen's team, who referred to the outsiders as delinquent non-parties, so you can call them house defendants, outsiders, delinquent non-parties. They have many names. The ham, you can call them ham. That's what I prefer to call them. I love the name the internet gave them. I think it's hilarious. So while the delinquent non-parties pointed to the judge's ruling regarding Colin Albert and that it should apply to them, Reed's lawyers countered that these witnesses are completely different because they were actually inside the house when the core events happened. Wasn't Colin too, according to them? Are they conceding that Colin isn't in the house? Because that's kind of how that's worded, but okay.
Well, but Colin was in the house.
I know that, but he's saying that they're different because they were actually inside the house. And that's why that's different than Colin. So I don't know. Furthermore, many of these same witnesses are already suing Karen for defamation over this exact situation. So they should have already expected to gather and share these communications. Exactly. What are we doing here? Now,
I feel like it's all for show. I feel like
It
these
is.
lawsuits are just all for show.
Absolutely it is. And like I asked you this thing, how come Carrie Roberts isn't mentioned in any of these lawsuits? How come she's not a plaintiff or
Ooh.
defendant? I don't know. We haven't gotten into the other cases, so maybe there's a reason why. They haven't said anything really about her at all in this one. But I mean, if you're talking about a conspiracy, then wouldn't Carrie be a part of that as well? I don't know. So then the same day, the plaintiffs are asking the court to compel Aiden Kearney, aka Turtle Boy, to turn in documents. By the way, I thought the image of Turtle Boy was great. I loved it. And then plaintiff C.F. McCarthy's Waterfall Bar and Grill, Karen Reed, and all of the lawyers submit their signed certifications that they did not disseminate any of the impoundment information the judge is really, really mad about. All right. Every single one that came in all said, nope, don't know anything about this. So let's watch this 15-minute emergency hearing, shall we? Here, it's a good one. Okay.
Wow. It's something.
It's something.
Well, it's something. I mean, it'll make you mad more than anything. It was kind of like, what? I'll tell you my feelings on it after you watch it, because I hope I didn't build it up too much. That's all I'm saying.
I mean, he sounds pretty big mouth, so I don't think so.
Yeah.
But he's on a pretty big mad in those orders. So also that, I'm sorry, Your Honor, but that robe is not flattering on you at all. You look like a giant, like, black potato or something with a head. Anyway, sorry, Your Honor.
This court now is session. Please be seated.
Your Honor, may I proceed?
Yes.
Your Honor, for the record, civil action 2483 CV
0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CF McCarthy's et al. Your Honor, with your permission, at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
Thank you.
Attorney Brillahante.
Present, Your Honor.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor. Attorney Holstag.
Present.
Attorney Rose.
Present, Your Honor.
Attorney St. George.
Present, Your Honor.
Attorney Donovan.
Present, Your Honor.
Attorney
Roll
Daly.
call. There's so many.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor,
All
attorneys
of the
Little and
attorneys.
Mason are
All.
appearing by Zoom.
Yes, Your Honor. Present.
Present, Your
Attorney
Honor.
Jackson's getting some free publicity as well. For
Attorney Jackson.
Present.
Attorney Seligson.
Present.
And Attorney Rosenberg. Present, Your Honor.
It is.
You can sit down. Thank you. So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function.
Oh, okay.
One commenter describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content, and the law has become...
Whoa, sir. First of all, it's been like this long before the internet. All right. Love history. I suggest you go back and start seeing all of the tabloids that would talk about, they would literally put pictures on the front cover of dead bodies. All right. Court TV has been around for decades. Stop. Is social media a bit of a problem? Yes, we do see that. People can go off on the deep end, but like, come on. All right. This has been going on for a very long time. We hear in a lot of trials we will hear this argument all the time about whether it should be streamed or not streamed because of the public and blah, blah, blah. And you know what? Some of the public does try to interfere in court proceedings. You see how serious this all is? You know, he wanted everybody to come in the courtroom where it's quiet because that's decorum. But I'm just, sir, stop.
A spectacle. I recently held a hearing on a non-party motion for protective order. I required the moving party to provide certain information. Such material was filed together with a motion to impound. A hearing that included the motion to impound was held on Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-parties counsel the opportunity to supplement the record before me.
It's Michael Proctor.
I scheduled the matter for further hearing that afternoon at 4:15.
What?
I watched that hearing.
Didn't we watch that hearing? No? Or is that one of the missing
No.
ones?
That's one of the ones you couldn't find, but I did watch that here. I watched it because EDB streamed it. And I watched that because there was like this big hearing and he wanted everybody to come in and they had to go back and forth about him delaying or not wanting to do the deposition. He took this big delay and decided he wanted to go think about it. He wanted to let the other side supplement the record. And this is the day that he was supposed to be deposed. And he didn't.
Okay.
Like the judge came in at 4:15 and he was like, yeah, well, he's going to go forward with the deposition. They're like, well, we can't do it today because the day is over. We can't do it.
Oh, I wonder why that trial.
And so they never, he's like, well, you don't have it scheduled for tomorrow? No, we had other things scheduled for tomorrow. Wait, you didn't think you only scheduled one day for the deposition? And they were like, we were going to reschedule because nobody could work on the next day. Anyway, it was a big clusterfuck. You need to find that. That was an interesting hearing as well.
Yeah, I didn't know that because there are some that I haven't been able to find. So I just assumed they were just closed.
No,
hearings.
it's out there because I watched it because everybody was like, well, you wasted the whole day, Judge. You wasted that deposition day.
Yikes. He's very contradictory. Oh no. Oh no. Oh boy.
With the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing and marked provisionally impounded was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel provide certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter. Of any of the contents of the material impounded on June 8th, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel, 32 of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the parties and counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded. Orders of the court have been violated either directly or at the very least in spirit. If these orders are to have any effect, all parties involved must operate with integrity. Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30. To any issue council may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases.
Oh, we're getting
In
homework.
the 2003 case of Buster v. George W. Moore, Inc., 438 Mass 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass Ave Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Gruhl, 399 Mass 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individual. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking.
Tick-tock.
My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct.
Not more rules, Your Honor.
Relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding. The rule applies to lawyers who are or have been involved in the investigation or litigation of a case and their associates.
Who do you think he thinks did it?
As the comment to the rule notes, it is difficult
Reed's team
to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence.
Okay, Jingris.
The rule takes into consideration that the public has a legitimate interest in the conduct of
Overrules
judicial
today.
proceedings,
Anarchy.
particularly in matters of general public concern. However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings. Read the rule, especially if you have never done so, adhere to it, or be ready to face the consequences for failing to do so. I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain.
Oh, history lesson. Like
Counsel,
Pooch.
do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy.
Okay. It's a weird birthday party
Continue to
announcement.
succeed with all of us working to maintain the rule of law.
Hey, we're so excited to
Thank
celebrate.
You're all right.
Oh,
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth session.
so he just made them all come in to yell at them? Well, not yell, lecture them?
There's no opportunity to be heard.
There obviously no opportunity to be heard.
I was unaware. I'm just covering for Clark Donovan today.
Oh.
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
I absolutely.
Thank you. That's it. That's it. One second. Yeah. It is someone which is incorrect or which is incorrect, actually correct. I have to correct that record. And everyone else should know.
He's not going to let us be heard for this.
Wow.
Well, we'll use that as another.
Wow. Okay. So he was like, nope, not answering any of your questions. Thank you very much. Over that. Wow.
Yeah.
Yikes. Call everybody in there and they don't get to say shit about it. That's wild.
Mm-mm.
Well, you may be wondering what could have possibly been posted online that's going to set the judge off, make everyone sign things under oath, make everybody come in and lecture them for like 15 minutes and then, walk out after a mic drop. What could possibly have been put out there on the internets? Well, Karen Reed's team is going to address this. So after this was over, because they weren't heard, they went ahead and filed. We're just going to read their two things that they filed, and then that's we're going to wrap up today probably. So On the first here, they filed this emergency motion to clarify the record. So today, the court stated on the record that an attorney with an appearance in this case had violated either the letter or spirit of the rule. That statement and those that followed were based on an incorrect premise. Namely, the information that the court claimed had been disclosed by an attorney was already public as of June 6, 2026, at the latest, more than 2 days before the filing or impoundment order at issue. Thus, the entire foundation upon which the court called today's hearing and admonished counsel was factually flawed. Oh, the judge is going to love this. Oh boy. On June 6th, the ex-user the court referred to today held a live stream on YouTube during which he stated that he had received the same information from a third party. That was 2 days before the impounded filing the court believes was improperly shared. That YouTube clip is contained on the USB drive attached as Exhibit 1. I assume they're referring to Turboy. Yes, I assume. The following post that also predate the June 8th impound filing also show that the information in question was public prior to that filing. So here we have a post from KY Maverick. Which do you believe will most likely happen Monday? Poll ends before Monday's hearing. Judge grants the motion, denied and deposition, denied and no deposition. Sherry Thompson says TB was live. The source, though not vetted, state that Proctor had been at McLean and transferred to a mental health facility in Florida. If that's true, did he have a nervous breakdown knowing AJ was posing him? Are the McAlberts concerned he is a weak link? Stated on June 6th, 2 days before. And then Petty Boop. I love that name. That's a good one. Good job.
Okay. So that's what was missing in the hearing. That's why it kind of got confusing, is that the reason why they had that hearing before this one was because Proctor wanted to move his deposition because of personal reasons, and they had him supplement the record. Yeah. And they're saying that's the stuff that got out, right?
Yes, that he was hospitalized for his mental health or whatever, I think is what they're referring to.
Yeah, and the McLean, it is, because McLean is the same hospital that is the mental health hospital that Lindsay Clancy was at. So.
Oh, okay.
Yeah.
So Petty Boop says, I'm sorry, but if Proctor is in a hospital in Florida, did they not know this before the close of business on Friday? So the public kind of already knows what's going on here, which is not a surprise at all. Now, they go on to say the court departed the bitch immediately after making these statements without permitting any counsel to respond. Defendant Karen Reed's counsel immediately asked to be heard to inform the court of these important facts that would correct the record. But the court refused to allow comment and refused to retake the bench when asked. Yeah, I wasn't very happy about that. Oh, hi. When you said the judge is going to love this, I remembered when EDB read this motion, she joked Aaron should have signed it, your humble servant. So the judge won't get mad. Yeah. Speak mad. He did not like that. So Karen's team files that the day after court. Then the next day, July 2nd, they file another one. This time they have included some other things, right? Because they're very worked up about this. So after the court's emergency hearing on July 1st, and after filing her emergency motion to clarify the record that same day, defendant Karen Reed became aware that the ex post that the court cited as the only evidence that its impoundment order had been violated was actually posted before the relevant June 8th, 2026 filing by third party Michael Proctor. The court stated at hearing that Proctor's counsel sent the relevant pleading and exhibits to the court and counsel at 2:22 p.m. on June 8th, and that the X post in question was created exactly 30 minutes after the email to counsel of record and contained information similar to the information contained in Proctor's filing. And that is incorrect. As the court can see below, the X post in question, which was provided to the court by Proctor's counsel, was created at 10:52 a.m. Eastern Time. The image provided by Proctor's counsel had a 2:52 timestamp. However, that is because it was apparently accessed by a user without an X account, which defaults the time zone to Coordinated Universal Time, which is so dumb, but whatever, 4 hours ahead of Eastern Time. When accessed by a user with an account set to Eastern Time, the post appears as follows. And it's a post from Aiden Kearney, aka Turtle Boy, from June 8th, all right, at 10:52 a.m. Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Because don't forget, the whole world found out he's an even bigger shitbag than we thought he was to begin with. It's so bad. It's so, so bad. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Karen Reed's lawyer made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue with based on her comments on the Today Show. He stayed the depo for 24 hours, and at 4:15, a hearing will be held. My guess is he's going to tell Proctor to jump on a plane and stop being such a pussy so Alan can depose him tomorrow. And he posted that June 8th, 10:52. Welcome back, Dean. Happy to see you here. So, yeah, it kind of seems like the judge is wrong in this. I see a lot of also speculation in this post here. That this is why. And
I
mean,
don't really doubt Turtle Boy.
what? Speculating?
I
Or
think
having
he.
or
Oh,
both?
I think he knows what's going on.
Now, the message was actually posted more than 3 hours before Proctor's filing and not exactly 30 minutes after it. Therefore, the court's conclusion that there has been a violation of its impoundment order is based on a factually inaccurate premise. The court's actions as a result of what it incorrectly determined was a violation of its order had primarily impacted Reed, who is the party who subpoenaed Proctor, began taking his deposition, scheduled a second day of testimony, and has spent significant resources compelling and taking his testimony. Because there is no evidence of any violation of the court's impoundment order, and because the court did not permit Reed's counsel to present any evidence on this point at the July 1st hearing, the court should now clarify that no violation took place and permit Reed to proceed with her scheduled day of deposition on July 14th. I don't think he handles being wrong very well there, but
No.
But yeah, if the timestamps are accurate on everything, yeah, I guess there is that. Okay, I'll get to that later. So that is where we're going to pause at for today because mom duty is just around the corner for us. Let me highlight so I know I did that for my own personal notations. And so that way I can be like, yes, Buffy, this is what we'll cover next week, which we will. We will be back to talking about Karen Reed and her civil trials next week. Because tomorrow we got Laura Owens and some other stuff. I don't know which day next week.
I don't even know what we're doing.
I don't even know what we're doing because I get to spend the next 4 days planning everything for the next several months. So
And then she'll overplan and she'll be like, I don't know why I planned so much.
No, I have to
I love you.
underplan.
I love you.
I didn't realize school was going to be this intense this year. So anyway, that's what I'll be doing. But we will get back to it next week for sure and pick up where we left off There was a hearing, I think, this morning, or there was supposed to be. Whether or not it happened, I don't know, because we've been live all day. But that'll be attached to the, proper spot in our O'Keefe wrongful death timeline. And then after we wrap that up next week, we'll be getting right into Ham v. Reed and Turtle Boy. And I'm really excited about that one because, as we know, the lawyers do not like each other based on a filing we read in here with emails. Also, we get to rewatch a lot of testimony from the trials because they reference it a lot and cite it a lot and put it in the exhibits a lot. So we're going to watch a lot of that again. And also, there's a lot of information about Turtle Boy, which I don't have. I think I've watched maybe a handful of his streams in the last several years. I don't have that kind of time um, or energy to watch him all of the time. So I really don't know a lot about his lore when it comes to the cases. Like, I really don't know that much. So I'm really interested to see those because I just went through one of his exhibits, which was a whole lot of articles he wrote. And I was like, oh, okay.
Sounds like we need to have Winks and Dean come explain that to us.
Yeah, you guys, Winks and Dean might have to come on and do some Turtle Boy lawyer, educate us about some Turtle Boy, because I really don't know very much. I mean, I know a little bit, but not really why. I know he has some court cases, criminally, some civil. I don't know why. I don't know any of that. I don't have that time. So maybe we can schedule something for that soon once we get into
Tell us all the
Ham.
stories.
So, God, we'll be here. It's going to take us a long time to get through the Ham and Karen Reed if we're going to be watching previous testimonies. So we're going to be stuck on that one for a while, which is fine. The other two aren't as interesting and will go on forever because the cops won't want to release anything. So it's fine. We've got the time, and it's relevant to all the story, or I'm sorry, all the cases, to go back and rewatch, certain testimonies and things like that. So, but that's one of the things I get to plan this weekend, and I'm very, very excited about it. So I'll be doing that. For that, we are going to go. You can catch me tonight, 8 p.m. Eastern, over on True Crime and Wine Time, where Terry and True Crime will be covering part 5 of the Sarah Hartsfield case we've been covering. The woman sucks, and she's insane, and she's just sucks, and we don't like her. She's the worst. So we'll be covering that at 8 p.m. part 5. And then Buff and I will be back tomorrow morning at 10 a.m. Eastern for more Laura Owens reading the transcripts from when David Gingras decided he wanted to be a YouTuber, a content creator that he talks shit about all the time. So that is where you can find all of us. All right, Buff. I know I always ask and your answer's no.
I'm so excited to read those transcripts.
Oh, I know, right? So yeah, it's a good time. It's a lot. You should go find my outline thing. It's going to be intense. So it's a lot to figure out. But it's going to be fun. I'm excited. I know, as I was like categorizing the trials, like both the first and second, and like because I didn't watch the first one. I only watched the second one. And we watched some of the trial, like testimony from the previous one. But I didn't realize how many people weren't called in the second one.
Yeah.
That in any normal case, they absolutely would have been called. That's why they were called in the first one. And so then the state was like, ooh, yeah, I can't call all these cops this time around. I can't call these house defendants this time around.
Yeah.
And so that's really interesting. I did not realize the discrepancy and how much it varied now that I know way more about all of this after
So
the
trying to
trial.
explain it to you while we were watching the second trial. Like this was a completely different trial. It's complete, like usually your second go around is just a repeat of the first. No.
Yeah.
This was a completely different story. And it was, yeah.
And there were several people that weren't on the stand for very long, like 40 minutes in the first one, and they're on for like 2 days in the second one.
Kate was on for like 3 days in the first one, something like that.
Yeah, a long time. She has like 7 different links. for her, all of her testimonies and stuff. So I'm really excited to go back and rewatch these testimonies again.
I'm glad because you know
so-
more and now you can be at the same level. I was watching the second trial because I was like, no, you need to hear what they say. No, you need to watch this. And you're just like, what? Like, what? Like, why are you getting? I'm like, no, you need to listen.
It's going to take us forever to get through these. I don't know. I'll sort
Yeah,
it out
because
this
now
weekend
you're
on how we're
going
going
to
to do it.
stop and have commentary more than I did.
Mm-hmm. Yeah, that's true.
Because now you're going to be listening for things you weren't really listening for in the second trial. Well, like when you watch the second trial that we had already known from the first trial.
Well, and I think too, like a lot in their motions and things like that, like they'll quote some of the testimony, right? But it's so much different than us reading it and then you just hearing what they say in their own words. Because it really, I mean, if there was one thing I really took away from watching that second trial is that everybody was acting like a shady mofo. Every person that got on that
Yeah.
stand, it was like, why are you being so cagey and weird?
100%.
You know, so even their mannerisms, their body, everything about it was just like,
well, reading it
sending red
in the
flags.
motion as opposed to seeing how they actually said it on the stand, we're like kind of it's like, well, I mean, put the body language. I know people don't put a lot of stock in body language, but and your tone.
And we're gonna basically rewatch most of the trials again
I'm
based on all the
excited for it.
different testimony they bring in where. So I get to plan all weekend, which I'm very excited because y'all know how much I love planning things. So
That's okay. I'll talk you through it. I can just hang out with you on a voice chat while you do it. We can sit,
Right?
talk about nothing or talk about everything while we do it.
As always. As always.
Yeah.
All right, friends. Well, we gotta go be, just some normal moms. We're just
I gotta go
normal.
get the peanut butter and jelly and go throw it in the back
Yeah.
of my truck.
We're just normal moms. That's all. But no, we will see you all later. Hope you guys have a fantastic rest of the day. I'll either see you tonight on True Crime and Wine Time, or I'll see you here in the morning. But until next time, my friends, go forth and be amazing. All right. All right. Bye, friends.